Hey, this is Tulsa criminal defense attorney Stephen Cale. I'm going to talk to you today about something that's so simple. It's something little that can keep you from getting into big trouble. Almost all my cases start this way. Somebody's not just arrested. They're arrested for some kind of traffic violation, and then through the course of that detention, investigation into that traffic violation, something bigger and more problematic comes out. So I want to talk to you about that today. So how can you keep something from turning into something big? Well, it's to obey the traffic laws. And that may sound so simple, it might even seem condescending, but let me kind of tell you why that's so important. Now, the Fourth Amendment to the U.S. Constitution protects us against unreasonable searches and seizures. And there's basically three kinds of intrusions, if you will, that the court recognizes. I'm going to list those just real quick. So three types of police-citizen encounters. One of them is what's called a consensual encounter. I'm going to talk about that a little bit more in detail in just a minute. But that doesn't really implicate Fourth Amendment protections. In other words, the Fourth Amendment doesn't apply to what's called consensual encounters. And then the second one is what's called investigative detentions, and this can even apply to traffic stops. These are seizures for purposes of the Fourth Amendment, but they have to be limited in scope and duration, and they have to be supported by what's called reasonable suspicion. I'm not going to go into detail right now about what reasonable suspicion is, and then there's the third, more intrusive one, which is an arrest that does implicate the Fourth Amendment. Now, all these categories are different, but they're not static. And what I mean by that is each one can escalate from another. So in other words, a traffic stop could escalate into an arrest depending on the situation. So a traffic stop is justified if an officer has what's called reasonable articulable suspicion. It has to be reasonable articulable suspicion that the motorist has violated some kind of traffic violation or regulation of the jurisdiction that they're in. So let me kind of give you an example of that. Let's use the old busted taillight example. So let's just say that there's a city ordinance that your truck or car tail light, the lens of it has to be intact. It can't have any cracks or holes in it. So let's just suppose you're driving and an officer's behind you, and for whatever reason that officer thinks you're a drug dealer. Maybe he just has a hunch. Maybe he just thinks that everybody is a drug dealer, and he's behind you and he wants to stop you because he thinks he's going to make a drug bust. Now, he has no basis for making the stop because he has a hunch or thinks that everybody's a drug dealer. But you've got this broken tail light. So now, because a city ordinance where you're driving says that you can't have a busted tail light, he has a reason or good cause to lawfully stop you because of that traffic violation. Now, why is that a problem? It's just a simple traffic violation. What's the big deal? Well, like I said, something as minor as that can escalate into something much larger. Now you've created a situation where you are interacting with an officer, and that can be problematic. Let me tell you why. Let's just suppose, and this happens all the time, you get stopped for a traffic violation, the officer approaches, you roll down your window, and the officer smells marijuana emanating from the car. Well, now you've given that officer legal justification to search your vehicle, and if you have drugs, other contraband, something else illegal in there, now you're in big trouble, and you can be arrested and charged for whatever crime. It might be possession of marijuana, possession of drugs. If there's large amounts, possession with intent to distribute, the possibilities could go on. But what if the officer doesn't smell marijuana when he approaches you? Well, maybe he has a drug dog with him, and he's going to allow the drug dog to sniff around your car, which in almost all circumstances is perfectly legal. Or maybe there's a drug dog in the area and he calls for one to come and sniff around your car. Again, in almost all circumstances, there are some exceptions, but in almost all circumstances, that's perfectly legal. If you have contraband in there, the drug detects it, again, that's going to provide the officer legal justification to search your car. Okay? But what if you don't have any drugs? No contraband, nothing in there. I don't mean no contraband, but what if you have no drugs in there? You've got something else. Maybe it's a handgun that has the serial numbers scratched off. It could be anything. And because of this encounter, you think that you have to consent to a search. The officer says, can I search your vehicle? And you not knowing your rights or being intimidated, being nervous, you say, sure. The officer searches your car, finds something illegal. Or, an encounter with police can be intimidating to some people. Police are allowed, so to speak, to be deceptive. In fact, they're trained to be deceptive. And that can result in some false admissions, false confessions, that might result in your arrest. And by the way, I want you to take a look at a couple of my articles on my website. One of them is called Police Trickery, the False Evidence Ploy, How It Hurts the Innocent and Impacts the Jury. That's one of them. Take a look at that. Really some good information in there. I think you'll find it helpful and educational. And then another one is called The Psychology of False Confessions. You might ask, well, why would somebody falsely confess to something? There's all kinds of psychology or reasons why some people might confess, and a lot of it involves police trickery. Okay? And then, other than false admissions, false confessions, here's another trick that I call. It's called the two-step sometimes. It involves a consensual encounter, what I just talked about a little bit earlier. And a consensual encounter is voluntary cooperation with a law enforcement officer in response to non-coercive questioning. And it occurs when a person's not in custody, whether or not they're handcuffed or not. Being in police custody doesn't necessarily mean that you have to be handcuffed. And I'll talk about that in another article and video. But here's kind of how that might play out, a consensual encounter or a two-step trick. So you've been pulled over for some kind of traffic violation. Let's just say it's by a highway patrol officer. And he asks you to go to the patrol car. You're seated in the front seat. He says, well, I've checked out your license. It's valid. Your insurance verification is valid. You did fail to signal, but I'm just going to write you a warning for that. And so the trooper says, okay, here's your driver's license, your insurance verification, and back, and here's the warning. And you say, oh, thank you. Thank you. And then the trooper says, you're welcome. Have a safe one. And then pauses for a second as you're getting ready to exit the patrol car. And he says, oh, by the way, can I ask you a question? And then the driver will respond, well, sure. You wouldn't happen to have anything illegal in your car, would you? The trooper will say. Anything like weed, drugs, anything like that? And the driver will say, well, no, you can search my car if you want to. That kind of stuff happens all the time. A person will just, try to appear innocent and say, no, you can go ahead and search my car. Or they might say, well, I have just a little bit of weed. And then that turns into a big problem. Consenting or admitting that you have something illegal. That's just one example. It's actually a common example. It happens all the time. So you've gotten a minor traffic violation or been stopped for a minor traffic violation, and that's escalated into an arrest, being jailed, and being charged with a more serious crime, whatever the crime might be. Can you defeat a bigger charge after some kind of minor traffic violation? Well, the answer might be yes. It depends on the facts and circumstances of the case. But it is possible, and in a lot of circumstances, to beat the bigger charge. And here's some of the things that I look into. First, was the traffic stop justified in the first place? If it wasn't, if it was somehow invalid, then any evidence stemming from that traffic stop could be thrown out and the whole case dismissed. Another thing that I look at was, did the stop last longer than necessary? So in order for the stop to be justified, it has to be limited in what's called scope. So if you're just being stopped for, let's just say, it doesn't apply to Oklahoma anymore, but let's just say an inspection sticker, or let's just say that an officer thought that you had an expired tag. It turns out it really was valid. That has to be limited in scope. And then the duration of the stop has to be justifiable. It can't be prolonged. And so if it was prolonged, that may be a basis for getting evidence thrown out and the whole case dismissed. If you consented, was it voluntary? Consent based upon, or a search based upon consent is not valid if it was coerced. In other words, the consent must be voluntary. If the consent wasn't voluntary, it's very possible that that evidence that was obtained based on your voluntary consent can be thrown out, and again, the whole case dismissed. And then, were you read your Miranda rights if you were in police custody? And again, being in police custody doesn't necessarily mean you have to be handcuffed, but if you were in police custody, did the police read you your Miranda rights? In other words, your right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to hire an attorney to represent you. If you cannot afford an attorney, one will be appointed to you. Do you understand these rights? If the officer did not Mirandize you or read you your Miranda rights, then evidence obtained as a result of that custodial interrogation, the seizure, could be thrown out, and again, the whole case dismissed. Whether or not these legal defenses apply in your case is going to be dependent upon the facts of your situation. Cases differ. Each set of arrests or stops are different. But I can't help you if you don't give me a call. I'm Tulsa criminal defense attorney Stephen Cale. Give me a call at 918-277-4800. That's 918-277-4800. I dedicate my practice to criminal defense. I've been in practice for almost 20 years. Don't just take my word for it. Take a look at some of the testimonials. These are real clients that have no incentive to give a good review other than they were just very satisfied with my representation. Take a look at the testimonials section on my webpage at calelawoffice.com. That's Cale, C-A-L-E, lawoffice.com. I hope this video has been helpful for you, instructional, and give me a call.